Good afternoon and welcome back to the East Carolina Law Group. My name is Attorney Tim Koller, and you have reached us through our website at eastcarolinalaw.com to see this video series. And this segment of this video series is going to be called Pro Se Pitfalls, the Do's and Don'ts of Self-Representation. What does pro se mean? Well, let me first just say this. If you're watching this video and you're saying to yourself, I'm going to represent myself, but you don't know what the word pro se means, you shouldn't represent yourself. Pro se means unrepresented party. It means you're representing yourself. There's an old saying, he who represents himself has a fool for a client. There's a number of reasons for this. First and foremost, let me just say this much. I don't even represent myself if I need it. I've had situations such as traffic tickets and things of that nature that I've really wanted to represent myself on. But taking the advice of my better half, I hired an attorney. Not that I'm not competent to handle my own traffic matter, but there are certain things such as bias and prejudices that you carry with you into your own case that can, number one, cloud your judgment on what's important in the matter, number two, prevent you from spotting proper issues, and number three, can allow you to miss the bigger picture and possibly successfully handle your own matter. Don't represent yourself. It's almost never a good idea. I'll go this far as say it's never a good idea. Hire an attorney. Pay for an attorney. If you are in legal trouble, pay for an attorney. If you are in a situation where you're indigent, meaning you have no money. Again, if you don't know what the term indigent means, you shouldn't be representing yourself. In order to properly represent someone or yourself, there is a whole host of things you must understand. First and foremost, the main thing to remember is, if you plan to represent yourself on any type of matter, you are going to be expected by the judge to be competent as a lawyer. That's a hard pill for a lot of people to swallow. You can represent yourself. Just because you can doesn't mean you should. You can cover yourself in dead fish and pig's blood and go jump into shark-infested waters, but you shouldn't do that either. Now, the reason is that you can't clearly see the issues if you're representing yourself. But the second thing is that there are things that you have to know to actually competently represent yourself for someone else, which is why becoming an attorney is such a strenuous process. The process to becoming an attorney requires 4 years of undergraduate education, preparation and passing the LSAT, acceptance to law school, at least 3 years in law school, and then about a year preparing and passing the bar exam and going through all the rigors that entails. And some of us, such as myself, have an intermediate graduate degree. I have a master's in American Legal Studies. So I had added 2 years onto my educational process. The important thing to remember is the reason that we have so much education is because there's a lot to know. So for you, as the pro se person trying to represent yourself, you are at an extreme disadvantage unless you are a licensed attorney. And even if you're a licensed attorney, it's not advisable. Get another attorney to represent you. It's extremely important that you produce a well-presented case, meet all statutory timelines and procedural timelines, and put all the right checks in the right boxes to make sure that you have the best possible outcome. Many of the do's and don'ts that people come into contact with is there's a lot of self-help organizations out there and self-help companies such as LegalZoom and others. Now, I will say this much. If you go to LegalZoom to do, say, a simple will, and you complete a simple will, or say a separation agreement, and you complete that document, and you take all the right steps, you're going to get a document that's legally correct. But there's a difference between legally correct, procedurally correct, and substantively correct. Procedurally correct means you've met all the procedural hurdles. Have you done that? Do you know what those are? Did you know that in North Carolina, spouses can enter into binding agreements with one another, but there must be full and fair disclosure of all material facts? What's a material fact that's relevant to your case? LegalZoom can't and won't tell you that. Substantively, is the outcome of that agreement in your best interest? LegalZoom can't and won't tell you that either. So when we talk about these things, we always like to say, you're not going to get something that's legally wrong from a company such as LegalZoom, but you may not get something that's right. And by that, I mean something that's right for you and that has met all the procedural hurdles. Because what they're doing is they're producing a legally valid document for you. So there's no onus on LegalZoom. They've done their job. They've not done anything incorrect, per se. But the onus is on you to make sure that it is correct. And if you don't know all those things, you're setting yourself up for failure. And unfortunately, we make a lot of money in this profession, particularly in this area, on folks that try to do their own legal work. We've had many instances where folks have gone on websites such as LegalZoom, and there's many others. I'm not trying to pick on LegalZoom. They produce very good documents. However, we've had a lot of money made on folks who have done their own legal work, produced their own documents through a self-help service such as LegalZoom, who have then filed them and come back sometime later only to realize that they've basically put themselves in a bad situation. And then you have to go and try and fix that. An ounce of prevention is worth a pound of cure. First, do's and don'ts. Don't represent yourself. Do's, hire an attorney. And go back to our other videos in the series where we talk about how to select the right attorney. That's very important as well. Finally, if for some reason you can't maintain your attorney that you do hire, don't think that you can get them to do the brunt of the legwork and drafting and then get rid of them and take it from there yourself, because you're probably going to mess it up even worse. Something that's very, very important to understand if you do decide you're going to represent yourself, despite the advice that we're giving you not to do so, is you have to have a working understanding of various legal definitions. One thing that you're required to have whenever you start law school, the very first thing you're required to have is this: Black's Law Dictionary. See the tiny print and how much is in there? It's quite a bit bigger than the average dictionary. Now, the reason we have to have this dictionary is because for about the first year of law school, it becomes your best friend. Because you have to look up terms such as jurisdiction, what the different types of jurisdiction are, lis pendens, latches, res ipsa loquitur. These are all legal terms that if you don't understand what they are or what they mean, you're going to be in a very big bit of trouble. Collateral estoppel. Now, this is one that I see a lot in pro se litigants that they don't understand. And I'll give you an example. I once worked on a case where a former domestic partner, a young lady, had filed a domestic violence protective order against her former live-in boyfriend and the father of her child. She filed this domestic violence protective order, failed to prosecute it, and it was dismissed on the merits. Subsequently, we were retained to represent the father. The mother returned an answer making various allegations of domestic violence. On the first hearing, we filed a motion to strike that was granted. She was representing herself. She could not understand why the court had struck the allegations of domestic violence. The reason is, you only get one bite at the apple. Collateral estoppel is very similar to double jeopardy. In a civil context, it effectively means that if you raise a claim and make an allegation and you fail to prosecute it, or you lose on those allegations, you cannot return them to in a subsequent hearing with the same parties seeking the same relief. In North Carolina, a domestic violence protective order applies the same standard of evidence and has the same remedies available as in a custody action. So because she had represented herself twice, brought the allegations incorrectly, and was dismissed on the merits for failure to prosecute, she was barred from bringing them later. They may have been very, very important and very relevant, but had she obtained the services of a qualified attorney, any attorney worth their sand, even a third-year law student, would have told her, this is a bad idea, because these claims are so important, they should be brought in the context of a custody action, not a domestic violence order. So, don't represent yourself. Now, if anybody watching this right now, apart from a licensed attorney, knew that information, then go ahead, represent yourself. But I will almost guarantee that most of you, unless you've got some extensive legal background, doesn't have a clue as to how that works. If you don't know those things, don't represent yourself. Self-representation is a bad thing. Estoppel basically means you can't bring it. It's like a great big barrier. So understanding what those basic legal terms mean are very, very important. If you want a general idea of basic legal terms, we'll be publishing a blog on our website. And by the time you see this, hopefully it'll be up. That's going to have some basic legal terms on there for you to get a general idea. Now, this is in no way us advocating for you to go out and try to represent yourself. This is so that if you do retain the service of an attorney or our firm and you have questions on certain things, you can just self-refer there and see what these things basically mean. But remember that anytime you're dealing with law, law is not black and white. Lawyers operate in the gray, and the law operates in layers. Just because a law says you shall not do X, Y, and Z doesn't mean that it's not pulled apart and broken down. You have to understand how these things work if you're going to competently represent yourself. And unfortunately, many times, people who try to represent themselves and subsequently come find an attorney are often told it's going to be extremely expensive. And the reason is because, again, as I said earlier, an ounce of prevention is worth a pound of cure. If you go into a situation and you make a mess of it, it's going to cost you a lot more to try to fix. And sometimes there's no fixing it. So I want everybody who's watching this video to remember that. Contact the services of a qualified attorney. Talk to them. Understand how their fees work. Hire them, pay them, and work with them. Your attorney is not working against you. Your attorney is your friend. They are your advocate. Even though an attorney may tell you something you don't want to hear, doesn't mean that they're working against you. Even if the outcome is not what you expected, it's not always the attorney's fault. Most of the time, it's not. The majority of complaints that go to the state bar are often dismissed. The reason is many times those complaints are being made by clients who are effectively, and for lack of better words, crying over spilled milk. A lot of times it's a failure of the case, not a failure of the attorney. The facts just didn't line up. And a lot of times clients think that they can just throw money at an attorney, it's going to make it all better. No amount of money is going to make your case better. If you have a good case, you have a good case. Doesn't matter how much money you have. If you have a bad case, you have a bad case. Doesn't matter how much money you have. The thing to keep in mind is this, and we push for you to hire an attorney. We're not saying hire us. We're saying hire somebody. And this applies to any state and any jurisdiction. If you're watching this from out of North Carolina, hire an attorney before you go forward. Thank you very much for tuning in. I hope this was informative. Refer to our webpage for our blog section. We're going to have a definitional list for things for you to understand, but it's very, very important that you know those things. And look for a future video that's going to be coming out here very shortly on basic court structuring in North Carolina and how court jurisdictions work. It's going to be a very basic intro. Once again, it's not designed for you to go out and do these things on your own. This is designed for you to have the information so that when you go to see your attorney, you know what they're talking about. Thank you for tuning into the East Carolina Law Group, where your family is our priority. You can find us on the web at www.eastcarolinalaw.com. You can find us on our Facebook page at the East Carolina Law Group. You can also call us at 252-453-2273. And if you want to find more videos and keep updated on when we put some more of these kind of things up for some more self-help kind of information, you can do so by subscribing to our YouTube channel by clicking on the link right about here. It's there. Down. Yes, right there. Subscribe by clicking our link. Thank you for tuning in. I hope you found this informative and have a great day.